Today, I'm joined by David Fisher, Senior Counsel at the American Antitrust Institute, to discuss his recent commentary, Closing Costs, a Critical Examination of the DOJ's Proposed RealPage Settlement. And David, thanks for doing this today. Oh, hey, you know what?
Yeah,
Anna,
thanks so much for having me.
Anna, did you get, sorry, David, did you get a delay? Sorry, we're having some technical difficulties. I couldn't hear David. Did you hear that? Did anyone else?
We do have a delay, Teddy.
Okay. Hey, David, can you try talking again? Sorry.
Hello, test.
It's like 10 seconds delayed, or not 10 seconds, like a few seconds delayed. Do you want to try? What should we do, Anna?
I'm going to send a prompt to David.
Okay.
And so if we could just hold tight for a minute, and sorry about the difficulties, everyone.
All right, so we'll get David back ASAP here. Again, well, you know what? While I have this audience, if you have questions, please enter them in the questions pane or email us at editorial@thecapitalforum.com and we'll get to your questions. David, we've got you back. Let's try the audio again. Can you?
Hello.
Yes.
Thanks for having me.
We're here. All right, perfect. So maybe we could start with RealPage litigation that the DOJ brought. Just big. Why did the DOJ sue RealPage, and what did they allege? And then after that, maybe we can get into the settlement.
So DOJ brought a complaint alongside several state attorneys general. And that's important to note right out front, right? That the settlement that we're talking about is just with DOJ and RealPage. So the state AG's case will continue. But the complaint alleges that essentially RealPage is serving as what we call an algorithmic cartel manager. And that's a sort of an antitrust term for an algorithm which functions to collect data and set a common set of pricing rules that competitors follow. So the allegations are as follows. RealPage is a algorithmic pricing software provider for multifamily landlords around the country. And they enter into licensing agreements to provide pricing recommendations to these landlords of, owners of multifamily housing units, where the landlords give up some commercially sensitive data, and RealPage uses that data both to train its algorithm and as an input that it uses to make a pricing recommendation to the landlord. So that's the basic business model. Landlords can accept or decline the algorithm's price recommendations, but there's allegations in the complaint that RealPage actually disincentivizes them from declining and encourages them to adopt an auto-accept feature such that the recommendation is immediately incorporated into their pricing. And DOJ alleges that the widespread adoption of RealPage's software has increased landlords' market power in real estate markets across the country and actually raised rents above the competitive level in those markets. So just to take that back, this is a set of facts that we've seen in a couple of cases now. Most of them are brought by private plaintiffs. But it very much follows the standard set of allegations that we've seen in algorithmic price fixing cases.
So we have this case. It's basically that they're helping, this software is helping landlords increase rent prices using, it's creating monopoly problem of increasing these rent prices across the country, where RealPage is providing services to these landlords, sort of helping them collude allegedly. And so, you know, DOJ comes out and settles. How unusual is it for DOJ to settle, but the states don't also settle? I mean, you know, it happens every now and again, but it seems pretty rare historically. What do you make of that? Or, you know, that seems, is that atypical?
I mean, like you said, it happens. I don't think there's necessarily a standard playbook that these things go. It's really much a case by case sort of situation. And I will also say that, you know, there's a lot at play here that we're not privy to. So obviously the parties have a much better understanding of the sort of risk assessment involved in each of their cases. DOJ has a complete other set of concerns that a regular litigant might not, about allocation of resources. It's got a lot of other business going on. It spends taxpayer money to prosecute these cases. And so there's a cost benefit analysis there in terms of the settlement. From my view, you know, looking at the outside in, it's an interesting opportunity because we can sort of get the best of both worlds, where we have, you know, DOJ, a really key player here, setting out a list of terms, which in its view is a reasonable resolution for the case. But we also get the benefit of continuing the litigation with the states at the wheel. And I fully expect the states to continue the litigation vigorously. And so it'll be interesting to see how that plays out. But it does make for an interesting set of facts here. There's a lot to pay attention to moving forward.
You know, one interesting thing before we get into your, you know, analysis of the settlement is that when you bring things up that are potential weaknesses in the DOJ language, or they could take steps going forward to fix that, and then that could also come up in the litigation from the state. So this is kind of a very timely, high impact analysis from that perspective, or is that not the right way to think about it?
I'm happy to see it that way. I'm glad you see it that way. I mean, from our perspective at AAI, we're kicking the tires. You know, we're looking at the settlement, like I said, as outsiders to the litigation, but as, you know, well-informed parties who've thought and written a lot about these issues in the past. There's utility to it, I think, in a lot of ways. Most obviously, you know, there's the standard public comment process that happens under the Tunney Act, which, you know, we filed comments. We appended my commentary to comments that we filed with DOJ, and they will respond to those comments and do under that process. And, you know, they might answer our questions, elucidate some of these issues. They might make amendments to the terms of the settlement. And then moving forward, if and when DOJ gets a settlement approved, the states can use that as a baseline for the kind of things that they want to see or address in the litigation moving forward. And then I think there's like the sort of the broader implications here, which is not just about RealPage, but more about how the courts and policymakers and business leaders are viewing this kind of algorithmic pricing software and this business model, and how we should be treating it moving forward. So I think there's a lot to learn from this situation, and there's a sort of a wait and see element to the degree to which the settlement terms actually sort of accomplish what they say they're going to.
And I know the paper is about sort of the details, but before we get into the detail, I have one more process question, because if you look at a lot of what's going on at DOJ, antitrust division, it is kind of unseemly and unprecedented in terms of there is another Tunney Act proceeding going on with the HPE merger, where there are allegations from states that the DOJ entered a settlement for political reasons, not for competition reasons. There's a lot of scrutiny there. We have that overhanging this Ticketmaster litigation that is about to go to trial as well. Is that coming up in this settlement at all? There were some questions at the time of the settlement that the DOJ leadership went and the White House went above the antitrust division's head, and you know, they have ties to private equity in this space, and maybe there was a little bit of deal making there. Does that come up at all, or is there any prospect of that coming up since you have this state on the other side of the federal government on an antitrust settlement?
Yeah, I mean, I'll say that our comments are not at all about the process by which this settlement came about, and I'm not aware of any specific reason to question that process in this particular case. I mean, you mentioned HPE Juniper and some of the other, you know, high-profile activity that's going on at the department right now. I think those are sort of a different matter from our perspective, and the commentary is very much focused on the terms of the agreement itself. And look, I think it's important to note that the agreement appears to be aimed at exactly the right thing, right? I think its aims are the right ones, and this is a much more nuanced question about whether or not the terms will, in practice, have the effect that it's clear that DOJ intends them to. And so we're not really talking about the sort of bigger questions of governance and process that are implicated in those other cases that you mentioned. And I just want to like make clear that in filing these comments, AAA is sort of engaged in the regular public comment process of any settlement. We're not challenging the validity of the settlement in any way. Like you've seen happen, of course, with the states in the HPE Juniper situation. So this is a much more sort of targeted assessment of the specific terms. Sort of
Seems like they're at some level operating in good faith with the overall, you know, scope of what the settlement terms were. And what were those? I mean, obviously, this business model is just on its face just a little questionable, just based on what we've seen in terms of rent increases across the country, in terms of articles discussing landlords now, instead of focusing on, you know, having as small amount of vacancy as possible, they're trying to maximize profit by having some vacancy and keeping prices high. That is sort of a new way of operating as a real estate owner. So we have some really heavy allegations here, really problematic market outcomes. And then you have this settlement, which, you know, as you mentioned, seems to be at least addressing the right things. What were those kind of high level goals of the settlement?
Yeah, that's a good question. So, you know, when I'm thinking about this sort of on the theoretical level, we use this term, algorithmic cartel manager, and that's a term that we've sort of taken from the existing literature, and it's a meaningful one because it ties this kind of conduct back to sort of long-standing, kind of old school Section 1 conspiracy cases. And I think that's a good framework for looking at the terms of the settlement. We have, there's like two main functions of an algorithmic cartel manager, and I think each of these functions are problematic on their own under Section 1 of the Sherman Act. The first is the function of collecting competitor data in a way that allows competitors to benefit from each other's non-public data. And then the second is the developing and setting a common set of pricing rules that competitors can follow. And so when we look at the settlement, we can see that all of the terms are aimed at one or the other of those two sort of problematic ways that algorithmic cartel managers function. So just to sort of put the terms in buckets, I think it's easy to think of them as like sort of three different buckets that the terms can fall into. The first is the ways that the settlement limits RealPage's ability to make pricing recommendations to one landlord using the non-public information of another landlord. The second bucket are limits on the kinds of non-public data that RealPage can use to train its pricing algorithm, to train its models that it uses when it's developing its algorithm. And the third are restrictions on the software features of RealPage's software designed to give users more control over the final pricing and output decisions. So I think we just to sort of take a step back, we can look at all the terms in those three buckets. And yeah, I mean, the commentary is sort of digs into the specifics of, you know, to the extent those limitations are meaningful, and we can dive into those, but that's sort of the three main areas.
Yeah, let's start with some of, because really what you dig into is how these terms could be interpreted in a way that's in the spirit of the settlement, which is dealing with this pricing collusion problem, or sort of just actually creating a loophole for RealPage to just continue to do what it does. And obviously, that's where the rubber meets the road. If it's comprehensively making RealPage change their business model and do something different that is, you know, sort of not going to raise prices, but actually going to make the real estate rental market, you know, more efficient, more, you know, when there's high demand, prices go up. When there's low demand, prices go down. More price discovery, not collusion oriented. You know, obviously that would be the goal of the settlement if we're taking this whole thing on good faith. What were some of what, you know, walk us through, let's just go through all the key terms that you think need to be defined more specifically so that there's no ambiguity in terms of how RealPage interprets this, because you know, we know if it's left to them with not enough oversight, you know, they're going to take the most generous interpretation that they can, I would imagine.
Yeah, so I think there's one key ambiguity that we identify, and it's kind of a textual argument, but what it comes down to is the scope of the limitation on the data that RealPage can use in making the price recommendation. So this is the first bucket. And just to sort of set the groundwork here, these terms are focused on data that are used in what's called runtime operation. That's the term that's used in the settlement agreement. And that's distinct from training. And to sort of understand that distinction, I think it's helpful to talk about in terms of ChatGPT as an example, because I think that's a technology that we all have some degree of interaction with at this point. So, you know, if you think of ChatGPT, it uses an algorithm that's trained on a massive amount of data during what's called the training phase. And that's before you or I as the users ever come in contact with it. And then in runtime operation, that's when I as a user will put in a question for ChatGPT to answer, and then it uses my question as an input and sort of generates a response. That's what's referred to as runtime, and it's sort of distinct from the training, which goes on kind of in the background away from the users. And so I think the ambiguity arises in the scope of the data that RealPage is allowed to use under the proposed settlement agreement in that runtime operation. And it revolves around the term subject property data. And the settlement agreement limits RealPage to using only subject property data in the runtime operation. And that term, subject property data, is defined as a property, kind of simply and maybe a little circularly, a property to which RealPage makes pricing recommendations, right? And so I think there's an ambiguity there because subject property can refer to only that one property that the algorithm is making a price recommendation for in any given one, you know, runtime operation, or it could refer to any property that RealPage gives pricing recommendations to more broadly. And there's a big difference there, right? Because if it means any property to which RealPage gives pricing recommendations, then the term would appear to allow RealPage to use all of its licensees' non-public data in making a pricing recommendation to any one licensee. And that's only a slight modification of RealPage's business model. It would prevent RealPage from using the non-public data of other entities that use other products. For example, its benchmarking products, which is also a source of non-public data. But it wouldn't prevent the sort of keep it in the hub information exchange that a lot of people have identified as problematic.
And also it's already pretty ubiquitous in a lot of places, so wouldn't help matters if you're
right. I mean,
if you use any RealPage customers data, that can be 100% of a market. And
there's markets, according to the complaint, there's markets where 80-90% of the market is using RealPage's software. So it's not much of a restriction, if that's what the restriction means. Of course, DOJ has been very clear in its competitive impact statement and in other documents when it released this settlement to say that RealPage is only allowed to make pricing recommendations based on the non-public data of the licensee to which it's currently giving price recommendations. And of course, that more restrictive meaning would be much more consistent with the goals of the settlement agreement, as we've just talked about. But as we write in our commentary, we think this sort of alternate meaning is also plausible. And I think, as you've alluded to, we've seen disputes like this arise in the past. When we talk about the Live Nation Ticketmaster situation, where the government approved the merger of these two parties with a consent decree, and the consent decree contained a term that said, I think it was that the combined entity couldn't threaten venues by saying that if they went with another ticket sales provider, that they would lose shows provided by the combined entity. And there was a seemingly clear term preventing that kind of threat, but the government got bogged down in a years-long dispute over what that meant. And Ticketmaster took the position that it was able to tell venues that they might lose shows if they went with another contractor, but that didn't amount to a threat under the actual words of the agreement. And so that just serves as an example of the fact that down the road, when other lawyers, not the ones who negotiated this actual settlement, are arguing before other courts about the meaning of these terms, they're incentivized to go with the interpretation that's most favorable to the defendant. And I think, our commentary is aimed at making sure that the DOJ is not assuming too much about what these words mean on their face, and making sure that the interpretation that we think it's clear that DOJ means, which is the more limiting one, is the one that gets adopted.
And also, these monitors that they appoint often aren't like the strictest oversight bodies. My experience with them is they don't really lay down the hammer on the defendant on these types of disputes.
I think more importantly than that is that the monitor is only bound to the terms of the agreement. And the terms are what the terms are, right? And so I think David Fisher, sitting here as a lawyer, sort of wondering about which interpretation is the best one here. That's the kind of opening that I think any contract lawyer would worry about, needing to be interpreted later in the future. And there's all sorts of complicated arguments that you can make about the spirit of the agreement or what the parties intended at the time and that sort of thing. But that's not the kind of dispute that DOJ wants to get into, down the road. So yeah, that's one of the key recommendations in our comment, is that the DOJ clarify those terms.
And what were some of the other recommendations you made where DOJ could strengthen the terms of the settlement?
Yeah, and this is still on the point of runtime data, right? And beyond the sort of ambiguity that I just mentioned, I think the issue of user inputted data is potentially a problem area from my perspective. And so this is data as defined under the terms of the proposed settlement agreement, that licensees collect on their competitors and then are able, under the proposed settlement, to input manually into RealPage's software, and which RealPage can use it during runtime to make pricing recommendations to that landlord, which just sort of on its own strikes you as a little strange. And I think it's even stranger in the context of the markets that we're talking about. I mean, DOJ and the states describe in the complaint concentrated markets around the country, local real estate markets in which only 2 or 3 landlords may own all of the multifamily housing units in that given market, and in which information sharing between those players is regularly occurring. They're regularly getting together and talking about pricing strategy and sharing non-public information or competitively sensitive information with each other. And, just sort of, again, looking from my outsider perspective at the agreement, I don't see anything in the proposed settlement agreement which prevents RealPage from being used to facilitate a price fixing arrangement that the parties themselves are able to carry out. They exchange the information with each other. They feed it into RealPage's algorithm, and it's essentially being used as a highly sophisticated calculator to tell them, based off of that competitor information, how they should be pricing. Of course, that kind of information exchange can itself be illegal under Section 1, but it's not clear how DOJ would be able to police all of these local markets and the ways that the local competitors are meeting with each other. And it does seem odd that such a settlement would allow RealPage to sort of serve that facilitating function. I did sort of have a chance to look at the settlement terms. DOJ has also settled claims against Greystar and some of the other larger property management companies that are also named in the complaint. And those seem to have terms which would prohibit the property owners themselves from collecting that kind of data and using it for pricing purposes. But of course, DOJ hasn't sued every landlord out there, nor reasonably could they. And it seems to me on the face of the agreement that these other landlords that use the product would continue to be able to do this.
It's almost like you'd be better off not addressing that at all, because you're sort of allowing for something that seems like it should be illegal, right? You're like kind of explicitly exempting something. Seems pretty unusual, to be honest, to your point. But also, but just going back to the ChatGPT analogy, it'd be you're getting your own sensitive, instead of, RealPage is banned from putting this sensitive data in an aggregate way. But if you want to go out and get it, you can just input it yourself and then ask the ChatGPT. It's like getting your own data and plugging it into ChatGPT and saying, what should the price be? You're just doing that with RealPage. Is that a fair way to kind of going back to the ChatGPT analogy?
Yeah, I think that's right. It's sort of putting the data collection aspect of it in the hands of the actual competitors, and using that common algorithm as a facilitator more for like crunching the numbers and providing the optimal output based off of that sort of already collusive data. Like an accessory, if you will, if you want to use the terms of criminal law. But I'll say again, as I have with these other terms, like there may be a perfectly reasonable explanation for why that's included. There may be sort of data-based, market power-based arguments why this level of competitor information doesn't rise to the sort of degree of concern that will give rise to price changes within a given market. But as I've said before, if we're taking all of the allegations in the complaint as true, it's hard to see why in an oligopoly market with only a couple of players that are exchanging significant information with each other, how that wouldn't be a problem. And I think that's something that we're hopeful that the DOJ will elucidate in its responses.
And we've talked a lot about how the buckets where they're using data and how they use data. What about just serving as the sort of conduit for price increases? I know that comes up in your recommendations as well. I think that sort of stands out to me as really problematic in terms of, if one thing I've seen from people who want to do more price fixing is they try to say, hey, look, the only thing that's illegal is if we get in a smoke-filled room and have an agreement, right? And that's kind of that's what they're doing with non-public data. They're saying, hey, non-public data is the only thing you should be worried about, we could still just do this as a software provider as long as we're just not doing anything with non-public data. That means we're not doing anything shady, right? We're not, that's the digital version of being in a smoke-filled room. But obviously, just serving as a centralized price recommendation allows for potential just consistent, hey, we're just going to recommend a higher price all the time, and you'll make more money that way. So what are your recommendations around things sort of outside this, how they input non-public data for the when it comes to the segment?
Yeah, and I think just to contextualize, I think what we're getting at here is the sort of the second function of an algorithmic cartel manager, which is not the data collection and use, it's the developing and setting common pricing rules. And the Supreme Court has been really clear on this, that Section 1 is violated when agreements disrupt the independent centers of economic decision-making that competition requires. So in order for competition to work and promote the best products at the lowest price, competitors need to be making their own decisions on pricing and output. And agreements are illegal under Section 1 when they make those pricing decisions joint decisions rather than individual ones. And so I think that's sort of what you're getting at when you're saying that, notwithstanding the data, it's the adoption of common pricing rules that is itself problematic under Section 1. So the way that the settlement agreement deals with that is to require software features that give landlords more control over the actual pricing and output decisions. And one of these features has to do with what's called guardrails, which are the limits on the amount that rents can go up or down over a given term. The proposed settlement requires users to have more control over those guardrails, such, for example, that prices can shift downward as often and to the same extent that they shift upward, if that's what the market demands. And I think that those provisions are sort of aimed at making sure you can get some of the same potential benefits of pricing algorithms with respect to responding quickly to market conditions, while limiting its tendency to drive prices upwards. And then another key element here is that the proposed settlement prohibits RealPage from requiring landlords to accept its recommendations, or pressuring landlords to accept its recommendations, or making it more difficult for landlords to decline its recommendations. And that's aimed squarely at this function of the cartel manager. A lot of people say that there's advocates out there who argue that there's not a Section 1 problem as long as the competitors maintain the final decision about how to price the unit. And that if the recommendation is just a recommendation, that's not an illegal agreement for purposes of Section 1. At the same time, though, the data shows that shared pricing algorithms tend to drive prices up even when users make the ultimate call on pricing. And I actually think the complaint is very good at explaining this and explaining it in some detail. So even if a landlord doesn't accept the price recommendation, they're still influenced by it in a way that affects the ultimate price. So let's say, for example, that the software recommends to every competitor in a given market that they increase their prices by 20%. even if all the landlords don't accept that 20% price increase, they're still influenced by it in a way that may cause them to increase their prices by a different smaller amount. And you'll see market prices go up by, say, 10%. And that, that increase in price is something that you wouldn't have seen under normal competitive conditions. And that coordination of pricing decisions can still be anti-competitive, even if the actual acceptance rate of the algorithm's pricing recommendations is actually quite low. And that's made very clear in the complaint. I think that the parties did a great job of pleading that. So that raises the question then, if the only way that we're addressing this sort of pricing rules aspect of an algorithmic cartel manager is to increase users' ability to set their own prices, how is it that those provisions are actually going to keep prices from going up in practice? And I think that's something that we've asked DOJ to sort of respond to. But I think there's a more important point here, which is that the precise dynamics of this, the way that this functions, are still up for some debate. And there's not a lot of data to work with here. And so I think the chief thing that we recommend in our commentary is that if and when the settlement is approved under whatever terms are finalized, it's critical for the DOJ to continue to monitor prices in these markets. Because, if they're right, and these sort of data restrictions and the sort of maintaining the freedom to make your own pricing decisions are sufficient to keep the software from having an anti-competitive effect on prices, we should see prices change in the future, so long as RealPage is complying with the terms of the agreement. We should see prices start to stabilize, even go down in some market conditions. But if we're not seeing a meaningful change from before the settlement to after in the markets that have been alleged to be effective, I think there's some serious questions about whether these terms are enough. And then, that's where enforcers, policymakers start to build from that and make better terms. But I think there's a lot of, like I said, sort of a wait to see element with that.
Yeah, they can look at pricing, but also marketing, right? If RealPage really fundamentally has to change their business model to be more about actual efficiency in the market with prices going up and down, they're going to have to stop saying, hey, we're going to guarantee that you're going to, the ways that you're going to make more money, right? You're going to make more money by lowering your vacancy levels, right? Sort of the traditional way that you've seen the real estate market function. So we should see more indicia of the market kind of changing as well, correct? I mean, if these rules are working as intended.
Yeah, and so you're talking about occupancy rates. I mean, right, like, and this goes back to something that you said at the beginning too. I think, when we're looking at, tacit agreements to collude, which aren't sort of written down, it's sort of when, in this case, the landlords that are all using the software never really talk to each other about how the fact that they're all using it, but there's sort of an understanding that they are. Those agreements to collude are illegal under Section 1, and they always have been, but they're very difficult to prove. And courts rely on circumstantial evidence to infer that an illegal tacit agreement exists. One of the key pieces of circumstantial evidence that is critical in these cases is if the individual competitor is acting in a way that's inconsistent with its own interest and only consistent with the common interest. And reducing output is a key fact that plaintiffs want to plead in these cases, because if I'm acting on my own as a competitor and I'm trying to get more, draw customers away, it makes no sense to leave apartments vacant. But if I know that my competitors are going to keep the same price, or at least not undercut me, keeping vacant apartments can keep the market-wide price high, and we both benefit from that. And I think the vacancy issue is a critical one when we're when we're looking at whether or not there's a potentially illegal tacit agreement there. Just by comparison, there's another set of cases that arise out of the casino hotel context. There's sort of two sets of litigation there on the Las Vegas Strip and in Atlantic City. And there, the plaintiffs pled that the incentives of the business model is typically heads and beds, because whatever money you lose at renting a hotel room for under the market price, you make back on the casino floor. And you want to fill up those rooms at whatever price you can, give them away if you have to, because you'll still make money in the casino. When you sort of see those casinos that are using the same pricing algorithm depart from that and leave rooms empty in order to keep the price high, that's a classic indicator of an illegal agreement here. And yeah, I think that's a key fact in a lot of these cases.
So while we're monitoring all of these provisions, let's assume DOJ does that, obviously there's still just the risk of doing an agreement like this with the potential for all these loopholes. If you're the states, what kind of remedy, let's say they ultimately prevail, what kind of remedy would they ask for that wouldn't get them stuck in this seeming brutal hellscape of monitoring and trying to get a monopolist to obey the law when it's not in their interest?
Yeah, I mean, that's the multi-million-dollar question, isn't it? I'll say this, it's not an easy problem to solve, partly because, it hasn't been done before. The reason why this proposed settlement agreement is so interesting is because we've seen a flurry of cases on the algorithmic pricing issue, but none of them have developed past the motion to dismiss phase yet, right? So we haven't gotten a summary judgment record or an opinion on the merits, let alone a remedy. And so it's sort of not clear what's needed here. I think that the data suggests that there's a potential competition problem when the same third-party pricing software is making pricing and output recommendations to multiple competitors in the same market, which combined have market power. What that means about a suitable settlement term, I'm not sure. It's very possible that, if we sort of address these issues that we've identified in our commentary, that, the settlement gets approved and we see a miraculous change in the way that the markets are working. And we find that, this approach of addressing data and addressing user ability to accept or reject pricings is an effective one. But again, we have to wait and see.
I mean, is there any kind of, normally it would say, oh, divest this or, structural remedy, but in this, it's getting to the heart of the business model, right? So what is the structural remedy that you would even seek? I guess we'll just have to wait and see what kind of more draconian measures could be implemented than what we're seeing here. But I'm certainly interested to see that as well. Let's move. We've got some listener questions here. Do you have anything else you want to add on what you want to see, David, before we get to the listener questions actually from DOJ in terms of fixing the remedy or clarifying it?
Yeah, I'll just, I encourage your viewers to read our commentary, which is posted on the AAI website. There's a whole other element here, which we just didn't have time to discuss, which has to do with the limitations on the non-public data that RealPage can use to train its algorithm. Just quickly, RealPage can only use non-public data to train its pricing models if that data is 12 months old and cannot be identified with geographic specificity more than statewide. So it has to be a year old and it's got to be state level. It can't be more local than that. I think that raises a whole host of questions about, to the extent this software is supposed to make prices more reactive to real world market prices, like, wouldn't you expect those terms to make the algorithm worse at what it says it is good to do? And if that's the case, then why has RealPage sort of agreed to those terms? And we get into the commentary more specifically about what the workarounds might possibly be in terms of using public data to supplement that old training data, and other potential sort of things that RealPage may be thinking. But we can't really make any firm conclusions without being privy to RealPage's sort of business thinking and sort of DOJ's deliberations. So yeah, that's another area where we hope that DOJ's responses will provide more clarity.
It also just brings up, I think you mentioned Zillow in there, or other public data feeds where, you can get a lot of transparency around rental pricing, from scraping the web. And, now you have AI and Zillow, and it just seems like, you whack-a-mole, right? Like, oh, you take away this, and then they're like, oh yeah, sure, 12-month delay, sure, yeah, that's okay, because they just turn around and do a deal with Zillow, and the data is just as good, right? Or what have you. So, and then it's like public data because like what, anyone can buy it, I mean, or they're scraping it, what have you. So, and then you're in a 10-year fight over the definition of public versus non-public. So
yeah, I mean, I'll say that like we're living in a new era where machine learning is making data much more valuable and also much more accessible. And in that era, I think this sort of red line distinction that a lot of folks have tried to make between public and non-public data is kind of losing its significance. And what we should really be looking at here are the numbers. Like, how are market prices being affected? And that continues to be the core focus of courts under Section 1, and really the bottom line for consumers here, and not sort of getting bogged down in specifics about what kind of data is being exchanged.
This is such an important issue. I want to get to our listener questions now. First listener question is, will courts look to the DOJ settlement when deciding other RealPage cases, particularly RealPage's First Amendment suits against states and cities? As a media company myself, I'm deeply offended that they would entertain such an argument in the first place. But go ahead, David. What are your thoughts here? Will they look at this when they're looking at other RealPage cases?
Yeah, I mean, the short answer is absolutely. What we're getting to here, and the reason why all eyes are on this proposed settlement, I think, is that this is the first definitive statement from really the leading enforcement experts here on this issue, the DOJ, listing out a set of terms which it deems suitable to address the harm alleged in this case. That gets to sort of the fundamental question about what it is in this business model that is problematic and what can potentially be saved. And I think that's a core question in all of the litigation against RealPage about algorithmic price fixing. So the short answer is yes. With respect to the New York State case, just for context, New York has passed a ban on, I can't recall, there's a lot of proposed legislation out there. I can't recall if it's a blanket ban or more of a targeted ban on the use of algorithmic pricing in real estate, which RealPage has challenged on First Amendment grounds. I think that presents a whole, RealPage's First Amendment challenge specifically presents a whole other set of issues related to the scope of the First Amendment and how it applies to law enforcement, which is outside the scope of my expertise. But in terms of whether and how RealPage's conduct violates Section 1 of the Sherman Act, yeah, this agreement is going to be part of court's consideration when thinking about those cases.
Yeah, again, as a media company, other companies using the First Amendment to protect themselves from a state wanting to, put rules on their society seems gross maneuver, in my opinion. But
I'll let you editorialize on that. But I do want to just add one fine point to that, what I just said, which is all the more reason why DOJ should articulate clearly the terms that it has adopted and the connection they have to the alleged harm. Because I think there's an important public record to be made here that will be used as a benchmark in the future, that courts will be using when they craft remedies, that litigants will be using when they come up with their own settlement terms or request remedies in cases, and that businesses are going to be using to determine which of their business practices are acceptable. And so I think all the more reason why we need transparency here.
Yeah. And yeah, I mean, there's just so much here. Like, why aren't they fighting DOJ on First Amendment challenges to put these rules on them? But here we go. How do the effects of algorithmic pricing vary between supply constrained and open housing markets?
That's a good question. I think it's a market question, right? And I think I can sort of respond generally. You know, I think the crux of these technologies is that they're really turbocharging competitors' ability to collect and use information on market forces, supply and demand. And public housing, you know, the availability of public housing in a market, the portion of the population which is eligible for that housing, all of those things are going to affect supply and demand in a given market. So I think it's a great example of when we talk about, oh, RealPage could be supplementing non-public data with publicly available data that it can use to train its algorithm. That's exactly the kind of information we're talking about. Information about the number of units available in a community and the number of people that are likely to apply for those units. You know, the availability of public housing is going to affect all of that greatly, and it's going to, you know, it's one of the things that makes these tools attractive, is because there's a lot at play here, and having the computing power, you know, to be able to make meaning out of them is really valuable. So I think of it as one more sort of market force that sort of RealPage is able to sell to its clients that it can help them account for.
And how is the DOJ likely to proceed on its crusade against algorithmic pricing? Will the settlement guide new DOJ policy statements?
Yeah, I have the same question. Yeah, I mean, look, as somebody who's been watching DOJ and paying attention in these kinds of cases, like, it's not a stretch to say that this agreement is going to give important insights into the way the government is thinking about these cases, both in terms of the conduct that they view as problematic and they're likely to go after in the future, and in terms of you know, its view of the risks of litigation in these cases and the, you know, reasonable use of government resources. Do I know beyond that, like, what's going on behind the curtain? No. But I suspect this will continue to be an issue. And, you know, I'll just say that, like, DOJ is not the only player here. I think the states are critical in the litigation landscape here. Private plaintiff suits are critical in the litigation landscape here. And while DOJ's conduct, you know, actions are an important sort of bellwether for how those other players are thinking about things, it's not the be all and end all. And that's why I think all eyes are sort of now on the states and on the private plaintiffs who are continuing these cases.
Well, another question here: if the court denies class certification in a RealPage multi-district litigation, do you think this crusade, it sounds like this person doesn't like this algorithmic pricing stuff, do you think this crusade against algorithmic pricing dies because the lead case has now fallen apart and we don't have precedent on the merits of these cases?
The word crusade has been used twice now. I don't know if it's commented.
This might be the same person. This is very much wanted to get a point across here, but you know, it's interesting.
Yeah. So without endorsing that terminology, no. I think is my short answer is no. I mean, the MDL decision is often meaningful in terms of that's what they're asking about, right? Whether
Yes.
the court's going to sort of approve consolidation of these cases against RealPage or allow them to continue in separate venues around the country. No, I don't think that the sort of litigation lives or dies on that decision. Often it's the defendants in the position of arguing in favor of consolidation because it makes it easier to defend cases in one jurisdiction rather than in multiple. So I do think that we're looking, you know, at AAI, I think we're looking more at the upcoming, you know, the anticipated Third Circuit opinion in Corner-Schneider v. versus Caesars, which is a critical, you know, it's going to be a critical opinion, I think, in terms of instructing lower courts on how to deal with allegations of algorithmic price fixing. We've already got an opinion out of the Ninth Circuit and Gibson versus Sendine on this issue that, you know, we've said at AAI publicly we think came out the wrong way. We're hopeful that the Third Circuit will get it right. But I think those opinions are really are going to be what district courts are looking to. And, you know, whether or not these cases against RealPage are heard in one venue is sort of an ancillary issue.
I think we got another question here following up. The question was about class certification, not consolidation. But
yeah, oh, right.
it doesn't really, I mean, look, yeah, well, go ahead and then I have.
Yeah, I mean, class certification is undeniably important in terms of the economies of scale, right? And that's why cases often, you know, why it's such a critical issue in litigation. But again, I think that we're going to continue to see challenges to this business model under any form. And the law is going to continue to develop here because it has to, right? This is a business model that's increasingly pervasive in our economy. It's showing up in you know, a wide array of markets, and it presents some serious issues on both sides. And so I think, you know, the courts are going to have to deal with it. Legislators are already beginning to try to deal with it. So I don't think it's going to go away anytime soon.
I just to put a focus on that point from a legislative standpoint, even if the courts do nothing and bless this technology at some level or create these, you know, sort of broad get out of jail free arguments, you're still going, I mean, it's not like the issue of affordability of your housing is going away. In fact, you know, most newspapers are saying this is the #1 political issue. The White House says it, Congress people running for election are saying it. You know, is this, do you agree with that this is going to continue to be a focus? It's in many ways sort of epitomizes this, are you going to do anything about high prices? The biggest cost for everyone is their housing costs. How could the focus of colluding on increasing your rent, or alternatively just the companies that do have market power, not just the software but the underlying consolidated real estate owners? I mean, even the president has said he wants to ban, you know, institutional ownership of rental housing. I mean, it's not like it's hard to see how this could go away. So, you know, even if you get one bad court decision.
Yeah, I look, reasonable minds can disagree about the extent to which algorithmic pricing is the cause of the affordability crisis in housing. And there's a lot of pressure on policymakers to address that bigger issue of affordability. But just sort of taking the algorithmic pricing part of it, we've already seen a slew of legislation coming from cities and states, and, you know, even bills floated in Congress at the federal level in Congress specifically targeted at this issue. And I think that's indicative of the sort of seriousness with which the voters are taking this issue. So yeah, I mean, I think the proof is in the pudding, and we're seeing all sorts of folks from courts to legislators to policymakers, you know, taking this issue seriously.
Well, David, you got some great questions. This was a truly interesting conversation. I can't thank you enough for doing it. It's great to see you. I'm so happy you're at AI. You had a great stint at the FTC. You're doing great work. This was tons of fun. Thank you so much for doing it. We did it. Thank you, David. Thank you to everyone for joining us today. And this concludes the call. Bye-bye.